Please join me in giving Trinidad Galdean a warm Pachyderm Club welcome.
Thank you, Todd. And I want to thank everyone for coming out, especially before the storm comes in that they're talking about. I've been practicing for about 26 years, and I came about immigration sort of in the roundabout way, not directly. When my main primary focus for many years was employment law, and because immigration flows into employment law issues, employment law matters. When I was working at these big, what they call these mega law firms with 400 attorneys and so forth, I would have to work on like Fortune 5 companies and Fortune 10 companies on their immigration issues and employment issues and investors and so forth. So it came about it from the employment end and from more of the investor end. Now, over the years, the changes that have happened that are going on with immigration have had a significant impact on businesses and how they work, how they comply with immigration laws first, but then also how they recruit, how they have get talent, and also with their growth globally. And so my practice has stemmed even more into immigration laws while still doing employment law, but also probably the last 2 years, it's gone into even more of what's called a family individual immigration, not just on business and employers, but also on individuals. But the presentation today is focused on immigration intelligence. It's to give you an overview of the immigration issues for someone that's here, that's a foreign national, or to come here, and that's a foreign national, and then also to provide you with some of the trends and hot topics that are going on with these various issues. And so what we'll be covering today, we'll be going through just sort of briefly the immigration background and going into the various immigration areas that are involved, and so you can understand how the buckets exist in immigration law, and then into visa, citizenship, and the current trends. Now, I would encourage you, if you have any questions, can you see that? All right. If you have any questions, please ask me. I mean, this is probably one of the few or only times that you can ask an attorney questions without being charged. So, please feel free to ask me. I encourage you to do that. Well, just some background on the immigration law is really the one that we're dealing with now came into effect in 1965, but prior to that, it really started in 1924, and it was created, the Immigration Act of 1924 was created primarily to establish a quota-based, it was a quota based on national origin of the U.S. inhabitants, okay? And really the intent at that time was to maintain some type of degree of the ethnic composition of American people. Well, by the time President Truman came into play in 1952, the act was amended. And at that time, the debate was that the immigration laws essentially were being applied in a discriminatory manner. It was a discriminatory policy. But what the debate was is that it was discriminating against Italians, Greeks, Polish immigrants. Okay, and when the 1952 law came out, President Truman vetoed it. His veto was overridden, and it came into law. And it wasn't until Kennedy and Johnson that there was another run of changing the immigration laws. And at that time, essentially, it was to change this national origin system of selecting immigrants. And President Johnson at that time had said that the quota system was defective, and primarily because it discriminated against all people who were outside of either Northern or Western Europe. And so they changed the system in 1965 to what would be 7 categories, 7 preferences. And if you have the handouts at the back, there's these preferences. But that's essentially what they came out with. and it came out with a numerical ceiling. So that's what we had in 1965. So since then, we've had, from the data, there's been 59 million immigrants since 1965. From that, the birth of the immigrants, there's been 72 million immigrants or descendants of immigrants in the United States. And then what we've seen is, at least as of 2015, that the population, the 55% of the growth has been from immigrants. Excuse me.
Was this legal immigrants?
Yeah, these are the legal immigrants, okay? So then what we have now, and then getting down into some of these issues on legal and illegal, or what's called undocumented immigrants. And so is that we have the data shows there's 31 million legal immigrants. From that, there's about 18 million that are naturalized citizens, 12 million that are legal permanent residents, and then about 2 million that are temporary legal residents. Temporary legal residents being they're on a visa. They're here and they're required to return back. Then it's all, as far as unauthorized immigrants, there's about 11.2 million unauthorized immigrants. Yes? Yes?
How do they gather these stats on?
Well, through the census.
How do you know there's 11.2?
And this is from the Pew Research. And so you can go and check them out and see how they gather it. But my understanding gets from the census, that it's, as far as gathering that information. Now, there may be some other resource, but I use the Pew Research just because it tends to be the more credible one. I haven't really looked to see how they go about doing it. But that I would imagine the 11.2 million is more of an estimate than a hard number, but because I don't think that everyone that's undocumented is going to fill out those forms. But nevertheless, that's what we have here for the best that we can check. Now, so immigration goes into two buckets. There is a compliance bucket, okay, and then there's an individual status bucket. Okay, the compliance bucket we're really not going to talk about, because the compliance deals with the documentation that employers or businesses have to keep on issues that involve immigration, such as whether someone's authorized to work, or whether only certain individuals can, with a certain status, can work on particular contracts if they're working as a subcontractor. So businesses, employers, and then the government have to keep this. That's the compliance aspect. I will tell you, though, as an update, when the compliance update, the compliance piece of it was significant, because if you recall, during the President Bush era, there were raids that happened and that were in the news of the big companies of Tyson Foods or McDonald's, or some of these places. Walmart was one of them. And what under the new administration, the issue that's come out is that they plan this year to quintuple the amount of work site enforcement. So from what we've had in the past. And in the past, that was less under Obama and so forth, but the instructions are that it's going to quintuple over this next year. But what we're really going to talk about here is status, the immigration status. If you do have questions on the compliance end, that's like your HR people complain about Form I-9s and E-Verify and those type of documents. I'll be glad to answer those. So status is the politically correct way in the sort of global term that is used when someone is here in the United States or in some countries. What status are you? You either have a visa status, or your status is going to be based on citizenship. Okay, so what is your status? Or you don't have status, so you're no status. You don't have status. You're undocumented. Okay, so you don't have status. So there's always the question when I deal with individuals, employers, businesses, and they're from China or other countries. Like, well, what's your status? They understand the term, so it's about status. That's what it's about. Okay, so for visa standpoint, and that's focusing on that part of it. So we have the two buckets, compliance and visas or status, all right? And so if we break down the status part of it, status is going to fall into two basic categories. It's either going to be employment-based, and the person a foreign national achieves their status here through their employer. Either they're sponsored or they're sponsored here, and it's because they have some profession, they have some degree, they have some knowledge, or they have some experience, and they're here for that particular purpose. And so here's the employment base. So the employment-based visas are going to fall. There's the temporary visas and the permanent ones. The temporary ones, well, both of them have to be based on an employer or some type of background, degree, work experience. But the temporary one, the individual has to return to their home. So what we have are, for instance, H-type visas and H-1B, which is where someone has a degree, maybe engineers, maybe accountants, could be finance, statisticians, and they're here for a period of time, anywhere from 3 years to 6 years. But the idea is that individual is going to return back to their home country. The permanent green cards, or the permanent visas, which everyone recognizes as green cards, are those where it's based on their employment, and they've secured it through their employment, and they have a particular experience, a particular background, and a particular background in a certain type of work. And those individuals are granted this permanent visa through their employer, but they fall under this preference category that I mentioned. And we'll talk about here in a little bit longer. In other words, they have to fall in line in order to get that green card. They have to wait a certain amount of time to do it. It's based on what's called a priority date. But just generally, just so you have an idea, from the employment-based, we had in 2016, we had 138,000 employment-based green cards approved just that year. And then in 2016, we had about 764,000 temporary employment visas approved. And that's going to be what's called an H visa, an L visa, an O visa, P, pretty much the alphabet type of visas. So the employment visas are essentially going to be based on the employer and the type of work. The next bucket, so we have a status, and your status is going to go either from employment-based or family-based. The family-based visa is essentially based on some relative, some immediate relative. Okay, and so these go into the preferences, and this is where it's a matter of whether what degree you're related to either a U.S. citizen that can sponsor you, or what degree you're related to someone that has a green card, a legal permanent resident. And depending on that degree, how close you are to that degree, will go into play as how long you have to wait to get that green card. All right. So you come in on a visa, okay, and you have to have some visa. You may be a visitor visa or whatever, an employment visa, or just a temporary visa. But then if you want to stay here because of a family member, you get that visa, and you're going to have to wait to stay here permanently for the green card. If it's a U.S. citizen that's applying for their spouse, or what's considered an immediate family member or their children, then the waiting period is minimal. It's just really how long it takes the government to process those. Okay, and so then the other preferences are based on, well, if their children are over 21, or if their children are married or unmarried. But what we have is, based from the 1965 Act, is that there's an annual cap on the number of preferences, family preference visas that are given. So there's 480,000 visas, that cap. All right, so that cap is met, and then once it's met and it's divided into countries and everything into categories, if you look at the back of the back 3 or 4 sheets where it has the preferences, you'll see how they're divided up. But once the cap is met, well, then people are just waiting. They're waiting for an open spot, or they're waiting till there's there's enough, for the next year. But if, let's say, in a particular country that had 20,000 available in a year, but there were 100,000 applicants, well, they're going to take the 20,000. There's 80,000. They're still waiting in line. So then, by the time they get to one of those, it may be 5 years down the road, or so many years down the road. And that's what you hear about when people apply for a green card from another country. That some of them had to wait 8, 10 years, 5 years to get to that stage. So your immediate relatives are going to be a spouse of a U.S. citizen, or a child that's unmarried and under 21 of a U.S. citizen, the parent of a U.S. citizen, and then a widower of a U.S. citizen. As a trend or an update here, this is the part where the new administration, this is the area where the new administration is saying that they're going to cut back on this. In other words, they're only going to allow spouses and children, okay, and also they're going to a scoring system. And that's what a scoring rating system. And the scoring rating system right now is being used by Canada and Australia. As an example, they would take into factors a person's age, a person's education, their income. They take into account all these factors, and if you score right now, if you score above a 30, well, then you're eligible. I happened just last night, because I was updating, and I saw the link or whatever on how the score would work, and so I submitted my information in there, and to see what kind of score it took. And I barely made it. But I barely made it because I had a higher than a college degree. So I inputted the information again. I put the information again with just a college degree, and I didn't make it. It got a score of 26. So I thought, well, let's see if I were to put in someone that's about in their 30s, okay, they have a college degree, and they make anywhere from $40,000 to $80,000 a year. They're capable of making that much money, and they're going to be in Kansas, and so all those factors. And that type of individual would score a 26, so they wouldn't meet the requirement. But that's the scoring system that's being discussed about right now. And that's part of I believe it's called the RAISE Act. The RAISE Act is that act. So when it gets to the issue of preferences, the first preference has first priority. In other words, someone has to wait till a spot opens, and those priority dates may go real slow or it may go really quick. You'll always see during election years, they move really quick. I don't know if they're trying to get people in that are going to vote, or if they're just trying to the government's trying to think, okay, we're working, we're working, we're doing our job. But the first preference is going to be to an unmarried son or daughter that's 21 years of age or older and a U.S. citizen. Okay, and so if you look back on the back of those pages, you'll see preference like F1, and you just go over if you're from China or India or Latin American country, Mexico, you'll see what priority date they're taking. And that means that if a person applied by that date or before that date, then they are able to move to the next step and get their green card. So that's what the back pages are there for. So that way you understand how this works. And then the second preference, as you go down in preferences, the dates get longer. There's the second preference, which is people who are related to legal permanent residents, people who have green cards. The third preference is people, married son or daughter, a U.S. citizen, and then the fourth preference is going to be brother or sister of a U.S. citizen. Okay. Now, once a person gets their green card, so then they've gone through this stage. They had a visa. They got a visa. Either they got it through an employer or business. They could have been an investor. There's investor visas. They got their visa, and then they moved into a legal permanent resident. Okay, and they could get that again through the employer or through a family member. And then the next stage would be a U.S. citizen. And not everyone that has a green card necessarily applies for their citizenship. The statistics show that about 80% of the people who actually have a green card will end up applying for a citizenship. And certain particular countries or individuals from certain countries will apply more than others. The trend here recently is that people from India actually are applying for their green cards at a higher rate than people from a Latin American country. Even though they're eligible, they're already there. That's just what the data is showing. But to apply for a citizenship, it's a matter of going through a background check, and they get the biometrics on the individual as far as fingerprints and pictures, and they check all the immigration systems to see if they come up in their data and their database as far as having any issues that might have been immigration related. And they'll check the person has to be here, a lawful permanent resident here for so many years. Generally, that's 5 years before becoming a resident. If they traveled outside of the country, they may have to make that time up. But also, if people are gone outside of the country, there's some investors that have had a green card, and if they're gone for 2-3 years, they could be viewed as abandoning that green card and have to start all over. So there has to be a continuous presence, and you have to be of good moral character. Good moral character essentially goes to crimes, paying taxes, things of that nature. Right now, the good moral character is being used. They're taking a hard line on good moral character, so individuals who had any type of drug violation will end up kicking them out to where they're not entitled, and also may end up kicking them out to where their green cards are taken away from them as well. So the good moral character is something that is being focused on right now. And then the individual also has to speak and write English, with some exception. The exception being if someone's disabled, or if you're at a certain age, I believe it's 65, and you get a doctor's note and things of that nature, you may be exempt from that. Okay, and then there's also the interview. Well, you turn in your green card, and then the interview. And the interview involves the English test and a civics test. And I can tell you the civics test is hard. Every time I go to one of these interviews, you have to get 6 out of the 10 right. And I always get 2 of them wrong when I'm sitting there with my client. And now they prepared and they've studied. I'll tell you, I didn't study for that, but it's not an easy exam. So, but once they get 6 out of the 10 right, and then they'll pass the interview as long as there's nothing else. But the interviewers are bringing up more issues. It used to be like I remember probably 2-3 years ago that attorneys, we would say there's really only if the client needs you or really wants you to attend the interview that we would go. Now that's changed to where attorneys are saying you need to have an attorney there, because there are situations where they're just detaining and deporting people right at that interview. If they find a misrepresentation in some document while they got in their visa stage, they'll bring that up. So then I put in here the requirements of as far as children being naturalized. That is possible, but just wanting to go to these other issues, what we're seeing now is a trend, and what's being discussed about now is the deportation and removal of undocumented individuals without a status. Now, individuals without a status can be someone that entered into the United States and they entered illegally, by whatever means, and so they don't have any documentation. But it can also be someone that was here on a visa, could have been they were visiting or was here working for an employer or something, and they've overstayed. So they're out of status. They don't have status. Okay? So what's happened is that with these individuals, and that's where the 11.2 million falls in, is that over the years, and back even from the Reagan era, the presidents have indicated that the United States just doesn't have the resources, the infrastructure set up to remove all these individuals, to go through the deportation and remove them. So it's a matter of what to do. But nevertheless, what we have now is that the trend is to use what's called expedited removals. okay, and to allow less discretion from for instance, the U.S. attorney that's prosecuting the removal, to where they were allowing them more discretion in either delaying it or seeing if there's some other reason that they could stay there or work something there. So when someone's in a deportation or removal proceedings because they have some problem with their status, and they've been out of status, they got stopped, or something has happened, and someone is called. I've had individuals that have called and said, someone's using my Social Security card, and that's reported through the whatever agency that needs to go through, and so there's that problem that arises. But the one that's really happened right now is going on is the commission of a crime. So what we've seen in the immigration world here locally is that when someone is getting a ticket, someone gets a ticket or gets stopped by the police are asking for their identification, and if they don't, and nowadays it's difficult to get a driver's license, or you can't get a driver's license without being having legal status, okay? And so they get detained. And in some communities, either they're working with ICE, and so they turn them over to the ICE agents. In some communities that aren't working with ICE, or aren't doing it overtly, they're just calling ICE up and saying, this fella's going to be out here in 48 hours at 11 o'clock in the morning on Wednesday, and lo and behold, ICE is waiting out there. So that's what's going on the detention. So it may not be that a lot of times these individuals have not committed a big crime as far as drugs or anything like that, but they have been stopped by the police, and now they're being detained, and now they're going through the deportation proceeding. So there's been a wave of deportation proceedings, of removal proceedings, and it's delayed things. Okay, and what I would compare a deportation proceeding is almost like a criminal proceeding. There's a bond hearing, there's a pretrial hearing, and then there's a regular hearing, and sometimes these deportation hearings and removal hearings in Kansas can take anywhere from a year to 2 years to get through the whole process. All right.
Meantime, where is that individual? Are they in custody or are they free?
Yeah, and the question was that in the meantime, where are these individuals, whether they're in custody or whether they're free? And it depends on the individual's background. So an individual that goes into a deportation proceedings or removal proceedings, they're put on, first ICE is going to see, what type of risk or flight risk they are. Okay, so you may see that ICE or Department of Homeland Security will say, okay, this person doesn't have a criminal record, they're married, they have kids here, they've been working, for however long, so they're not going to leave. So they may let them out, but they'll set a hearing date for them to come back, that they're supposed to come back and present themselves to the court. The other part is that if there is some type of criminal background, is that they're detaining them. So they're being detained by the government. For instance, here in this area, individuals who are detained are usually detained at the Chase County jail. Their county jail, they're being detained over there. People from Wichita and western Wichita, that's where they're being detained until there's a formal bond hearing. Then at the formal bond hearing, which is before a judge, then you have to give the judge some reason and some basis to say, hey, I have the ability to get legal status, and here's how. And the judge will set a bond anywhere from $5,000 to however much, and the individual is out on bond and then has to return again. But it's like that's what happens as far as where are they at. Okay, if they have an attorney at that stage, some of them will, and they file for some type of status, then they'll try to get some type of employment authorization, so that way they can work while they're going through their legal proceedings. So from a deportation proceeding, that's what we're seeing. Also, here recently, just within the last week, what we've seen from the new administration is that they're placing quotas on the judges to move these quicker, faster. So some of these, sometimes it would take, like I said, a year to 2 years to get to where there's a hearing, a master hearing, and they're saying, okay, no, these need to move quicker. So they're putting more pressure on the immigration judges. Okay, but also they don't have the number of immigration judges that they need either, but still, they're putting in place this immigration quota. Now, the current trends, what we have here is one of the ones that you may hear about is DACA, which is Deferred Action for Childhood Arrival. And DACA is that one of the things that people don't understand is DACA is not status. Like I mentioned earlier, there's someone having status. DACA is, the best way I can describe it is, when you get a ticket, you get a speeding ticket, and you go to the city attorney or the judge, and you say, and they give you diversion or probation or deferred adjudication. It's called different things in different jurisdictions. And it's pretty much, well, if you don't speed again for 90 days, this one's not on your record. And that essentially is the idea behind DACA. So what it is that these individuals have been in the United States, and these individuals that came to the United States before they were 16 years old. Okay, they came to the United States before they were 16, and they've been living here continuously since 2007. Okay, they also can't be 31 years of age when they apply, and they have to have a high school degree or GED, or they have to be in the military, or have an honorable discharge. And they can't be criminals. They can't have a felony, or they can't have more than 3 misdemeanors. So if they meet all those requirements, then they are approved for DACA. And all that is that you go to the bottom of the list, to the bottom of the pile. They're not going to deport you, but if you do something wrong, they are. They're going to pick you up, and you're going to get put into removal proceedings, deportation proceedings, and to be deported because you don't have status. Okay, so these are essentially individuals who a lot of times have come over because of their parents came over. They were, a lot of the ones that I see end up being individuals that came over before they were 5 years old and have lived here. And I can tell you that they don't speak Spanish, and all they know is what's here. So and a lot of these, what people don't recognize, some of these are working in banks, they're working in accounting firms, they're working in law firms, they're working, it's their EMTs, so they've been here, but nevertheless, the DACA program is temporary and was temporary under the President Obama's executive order. President Trump has said he's taken away that order, and now there's litigation about that. But it was supposed to end in March 5th. Yes?
How do they get a Social Security number if you're not a citizen in order to work in banks?
Right, and that's a good question. So how do these individuals get a Social Security number in order to work or things? So what happens under DACA, that gives you're just deferred. You're just in diversion. It's really what it comes down to. But you can ask for employment authorization while you're in that status. So you get an employment authorization card. It's called an EAD, but it's an employment authorization card, and that's what you give to employers if you want to work. And they'll have a date when that card expires. And when you go to work, the employer's supposed to, when it gets close to that expiration date, they'll ask you to provide some other evidence. And that's what's used. The employment authorization card will be used to get your Social Security card. Now, actually, what used to be, the individual had to get the card, then go to the Social Security Administration office, show them the card, and get Social Security card. Now, actually, there was one that was just renewed here where I was assisting a fella, and the Social Security just automatically sent the card. So, yes.
How long is the card good for?
It's just good for, like right now, DACA is only good for 2 years. So every 2 years, the individual has to renew it. Okay, and they go through the same process of, background check and everything else. And so the employment card is only good for 2 years. The Social Security card also has an expiration date of the same date. And so that has to be renewed. Because a lot of them were up for renewal, and President Trump said, okay, we're going to cut this off, a lot of individuals fell in that window to where they could not renew because of the timing. And that's in litigation as well, all those issues. As far as whether these individuals can continue to renew or what's going to happen. Some individuals have renewed and now they're up for 2 years, but who knows what's going to happen after that. Question over here.
Yeah, what's the status of a 9 months pregnant, just about ready to have a baby, and crosses over from Tijuana to San Francisco and ends up in the hospital at San Diego and has her child. And I understand the child becomes an immediate American citizen. What's the status of the mother? How long is she able to stay here? Does she stay here for 18 years to take care of the child until adult?
No, I mean, what happens in that type of situation now, and let me just preface this, that right now there is a policy that's gone out through the Department of Homeland Security of them detaining women who are pregnant, and there's a question of how that's going to work out. But if they do have a baby here, then the baby is a U.S. citizen. Now so the baby has status. Okay, the mother still doesn't have status. The mother has to go through some type of process, fit into one of these preferences in order to get status. What would more than likely happen is that she would end up saying that her status would be through a waiver, that the government would waive her non-status because a U.S. citizen, her son or her baby, would be an extreme hardship if she's not here to take care of the child or the baby. Now that would be a humanitarian type of waiver if she's not married and there's not a husband that can apply for her. Now, by the same token, those humanitarian type of waivers, those were discretionary through like the government attorneys, the U.S. attorneys. And that discretion has been taken away of like them saying, you know what, you're not going to be given these waivers, as easily as you were in the past. So that's not happening. So there's more scrutiny put onto the whole issue of waiver, someone having a waiver to stay here. And really what it comes down to get a waiver, you have to show it creates an extreme hardship on a U.S. citizen who happens to be your sponsor. But that citizen has to be an immediate relative, so it has to be your husband or your kid, your child. Yes?
Yeah, a follow-up question to his, because I'm curious about this. In that scenario he just described, how does that baby become a U.S. citizen immediately if that's her child and she's a Mexican national? That baby is not 18 years of age yet to make a choice to become an American citizen. How is that child given American citizenship automatically? That's a real one for me.
Yeah, and I don't know. I just know that people who are born in the United States are U.S. citizens. Okay, so that's now the baby may end up having dual citizenship, technically, but yes, I mean they're a citizen. Okay, so DACA is one of those areas that is hot and what's going to happen because these individuals are integrated into the U.S. system. They're part of the community. They've gotten high school degrees. They speak English. They're staying out of trouble and are providing something to the community. However, the idea is that they came here through no fault of their own. So whether that goes on or not, all the legislation has been that both parties seem to be in favor of something that relates to DACA. What is in disagreement is that, and I think even from both parties, is that DACA should not be a path to citizenship. And so that DACA would end up being sort of like a visa, like you have status. And if you mess up, well, then that status can easily be taken away from you. Okay? So then what we have had as of September 2017, there were 790,000 DACA recipients. All right. Then the other part, the caps on visa is important when it comes to businesses and individuals. So individuals who are sponsored by employers, let's say they're the H-1B visa, which allows individuals that have a college degree, either have a college degree or a master's degree, and you can come work for an employer here in the United States for a period of time. And but there's only so many. So as an example, an H-1B visa, they only allow 85,000 spots each year. And the first day the window opens for an employer to sponsor, to put in the application for that, is on April 1. Actually, it was April 2 this year. And there's 85 spots. There's 20,000 if you have a master's degree, 65,000 if you don't. Well, what we've seen over the last 6 years is that on the day the window opens, there's like 400,000 applications put in on the first day. Just driving over here, I received an email that they met the cap. And they usually meet at the first day, but they wait the whole week to tell everyone the cap's been met. So if you didn't file by the first week, you're out of luck. And what ends up happening is that it's a lottery. It becomes a lottery. But from an employer standpoint, the employer needing this individual has vetted this individual as far as coming here and doing the work. And it ends up being in places like in Wichita. We're not rural, but we're not big cities where we can't get some of these other engineers or this other talent coming in as easily, and so the employer ends up spending the money to try and get this visa, and it has to go through a lottery. Another one is, like if you read in the paper today, where in the construction industry in Wichita, we've seen that they're in need of workers. I have several clients in the construction industry, and so they get, because of the weather here up north, and I have clients in Iowa and in Nebraska who are in the construction business, and because of the weather, well, there's only a certain period to where a lot of the work can be done. And so there's these temporary visas like an H-2B visa, which are non-agriculture. And for the longest time, there was just 66,000. Well, that's all. There's just 66,000 that they give out each year. 33,000 in the first half of the year, another 33,000 in the second half of the year. And there's never been an issue up until this year. The day the window was open for the first half of the year, all the 33,000 visas were essentially taken out. They had more than 33,000 to give. They had something like 130,000 applicants. So what you have is businesses who are relying on those temporary workers to come in to help on construction, essentially labor, the hard labor, are now looking at, okay, can they take on these contracts? Can they do this work? Are the customer's going to be delayed? And what's happened? And we did see last year is that usually the first one is taken up, the numbers are hit. The window opens like on April 1 also. But the numbers are met usually about June, July. Okay, here this year, April, hit, or not April, they knew even before April, they knew in March it hit, and they just said we have more more applications than the spots available. And so what usually happens in October, what President Trump did last year, is he said, you know what, we're going to increase that cap and allow more workers to come in, increase it. And he did that last year. There's hope that he would do that this year. But what I'm getting at is that these caps essentially have not increased with the time, with the demand of what employers are doing and the business's needs. So that's been an issue. And then the enforcement, there's been the discussion about the wall. That's still up in the air. We're not sure. The due process is the expedited hearings that are going on. The travel bans, there are travel bans if employers have employees that come in from certain countries that are on that ban. Usually we have to show some type of business reason in our itinerary, more documentation that they can stay here for the employer. And then the employer compliance, the audits. Like I said, they're going to quadruple employer enforcement, worksite enforcement. Then as far as legislation, there's been plenty of legislation. Here I think what they're looking at is DACA is the first one that they want to deal with, but also what you'll see is that now with this notice coming out on the H-1Bs, meeting the cap again for the 6th year, and now it's occurring to construction and blue collar type work, laborers, you'll see there will be more of a demand for some type of immigration reform. But with that, that's all I have. I think I'm running right on time. Are there any questions? Yes.
That H-1B visa, remember Disney got into trouble with hiring people and laying off the American workers. And there was another company in California that was doing the same thing,
Right.
bringing in workers from India and laying off American workers. Where is that at?
Well, and the question is, when on these professional visas or employment-based visas where employers lay off U.S. workers, is my understanding. They lay off U.S. workers to try and bring in a foreign national under these visas. And that is improper. It's illegal under the program. So what happens is they end up being audited. There are more audits that are happening, which are called H-1B audits, or they're called FDNS type audits, and they're different than an I-9 or anything else, and they're more severe. And so they audit those. There's been more of those audits that have come out to see whether employers are doing what they're supposed to do in order to get those visas. In other words, you can't lay anyone off, and you actually have to disclose, have you laid anyone off within a certain amount of time, or a mass layoff during a certain amount of time. And part of the fees actually of the H-1B are just for that. Like employers have to pay $500 for each application. That's part of the essentially a fraud fee that they use to fund the investigations. There was a question over here?
Well, if you have a question, if you'll raise your hand, we'll bring the mic to you so everyone can hear the question.
Yep.
And we will usually prefer our members first.
Sorry, I don't have the terminology correct, but allegedly the administration discovered that Mexico is allowing people to come in south of their border, and they're giving them some type of papers to allow them to get into this country. Have you heard of that situation? I mean, it's pretty big.
Yeah. And the question is, about Mexico or a country giving papers for individuals to cross into the country. Now, I know historically there's individuals that do come in with essentially fraudulent papers. And whether Mexico's giving it to them or someone else, essentially a human trafficker is what they're called. In Spanish, they're called coyotes. They give them the papers, okay, to try to come in legally. Now that what's happening is, and this is part of the back when E-Verify was going on, back when it started. Now I'm not sure if some of you remember, and that was about 8 years ago here in Kansas, where Kansas was some legislation on E-Verify, and essentially changing that to where agencies were going to use information. Now they've gone to the stage where there's more biometrics on this. So you have more biometric information, and the whole purpose is to beef up E-Verify, but also there's been some discussion of creating a biometric employment card, but all this biometric ends up coming essentially to enforce our border. So there essentially would be the idea that it gets to where there's either some type of card or for biometrics. As you know now, you have to go and have more biometrics done if you want to fly in the United States. You have to get your different card, and that's part of the whole biometric system that's changing towards making it less likely that something like that's going to happen.
On the bottom of page 3, when you're talking about employment-based visas, temporary and permanent or green card, are there any qualifications or requirements that qualifies an employer to sponsor these immigrants? Did they have to be in business a certain period of time?
Well, there are some. I mean, the question is, are there any requirements on the employer? So yes, in other words, they do have to be in good standing with the Department of Labor. A lot of these require a pre-filing that goes through the Department of Labor, and the Department of Labor checks them out and makes sure that they have a tax ID number, and they'll see what type of business they're doing. You have to provide certain codes that identify the type of business that you're doing. So like, let's say you're a restaurant, well, why are you hiring an engineer, so to speak? So the codes have to match. So there's that, and then the income level. The other issue is that the employer does have to make enough income to pay this individual essentially the fair wage, what's called the prevailing wage, that they're paying everyone else and providing all the other benefits for everyone else. So there are some of those requirements and information that's applied.
So that would stop an immigrant or a group of immigrants from forming their own LLC and basically employing themselves.
Yes, in that aspect. So there are issues when investors look to come in, and maybe they have a rich dad or family member, and they try and create a company here. Well, the information that's supplied to the USCIS, the immigration agency, is like, okay, who are the investors? The person who's the beneficiary that's going to receive the card, the visa, do they have any ownership interest in the business, and how much ownership interest, because they can't have more than 50% or something like that. But even if they do, then there's the scrutiny of like, okay, well, why are they even needed? So there is scrutiny given on that aspect.
Any more questions?
How about people from Venezuela? Are they in any more preference because of the turmoil of the country compared to the United States?
It used to be individuals from a country where there's some type of turmoil. An example would be like Haiti, other countries where there's been earthquakes and things of that nature, to where they could come in and get a temporary visa. Essentially, they would come in as a refugee or seek some type of asylum. And that was the basis of their visa. And it was temporary in that they had to renew those however often, whatever the administration said. It's like they're renewed. Now, what has happened is that the new administration has indicated we're going to stop that. So everyone is in the boat. Now, in some countries, they just are requiring more documentation to make sure that they are refugees. So there are some problems, or that they were subjected to some type of issues. But the new administration has indicated they're called TPS, which are temporary protective something visas, TPS visas, and these essentially are being there's less of them being issued. So the administration has said, I believe they were issuing something like about 130 last year, and now they're saying, we're only going to issue 130,000. Now we're only going to issue 45,000. There was actually, the Department of Homeland Security said he only wanted to issue 15,000. And he was pushing for that. So there's, to answer your question, yes, because there's going to be less of those issued, and there's more scrutiny as to whether we're even going to give them or how long. The president has indicated that individuals like from El Salvador and some of these other countries, they're not going to renew them. So they, those individuals have to go back to their country or find some other way of getting status. Question?
The number one complaint I hear is the use of the welfare system by the immigrants, whether it be illegal or otherwise, but mainly the illegal. So just how much access do they have, or they're prohibited from gaining to the welfare system?
And see, here, visas, you don't have any access. A visa, you can only work at a certain place, and you can only work at a certain place, and you, as far as travel, you can stay, however long that visa is, and if there's something goes wrong, or if you're terminated, then within 48 hours, the employer is supposed to let you know. So they're not entitled to some of those benefits. Okay, if they're employer-based benefits, they would be entitled to that. Now, when you get into the green card, well, if you have a green card, you're entitled to those benefits. The only thing, a green card that you have different from a U.S. citizen is that, well, you can't vote, and if you commit a crime, you could be deported. So there's just a few things, from having a green card. So, yeah, if someone's getting those benefits, would be illegal. I mean, they're doing it through some other means, some fabricated documentation or something of that nature. Or the system is just not checking. The government isn't checking, the agency.
Thank you for this interesting information. If someone is in the Ukraine, it seems to me to be terribly unfair if they're fully documented, they have money, they want to come over on a tourist visa. It's impossible or near impossible, or was near impossible during the 8 years of the Obama administration for them to come over. And I don't know if there was a religious test going on, or some thought there was, because they belonged to the Orthodox Church. They would not come over. There was some Ukrainians came over, but they were not members of the Orthodox Church. Is that changing now? And can a person who is a bona fide person on a tourist visa that's going to be here for 90 days or something like that, is that going to open up? And the reason I say that, it's almost embarrassing. Ukraine is so nice to the United States. Any U.S. citizen can show up, show your state driver's license and your passport, and they'll give you a visa the minute you step off the airplane. And here to exchange, to have another person come over and visit, it's just about impossible. And I don't think that's fair.
And to some degree, it's not. When it's based on, in the cases that have come out, when it's based on some protected status, and that's similar to like in an employment area, if it's because of someone's religion, someone's race or age or gender and things of that nature, it's improper. And here, the first travel ban appeared to be based on or developed on a basis of religion, and that changed. But that was the argument that was being used. And so what has happened, while they're not doing that anymore, or they're saying they're not doing that anymore, there has been an increase in documentation. So when these individuals go to the U.S. embassy over there, let's say in the Ukraine, or they go to the U.S. Embassy in Macedonia or Pakistan and trying to get a visitor visa, they're being asked more questions, more documentation of where are you going to be, who's your relatives, where are you going to be staying at, whereas before that was perhaps provided verbally. If someone's coming in here for a business, some type of business activity, so it's a visitor business visa, they're wanting itineraries to show where the individual's going. There's just more scrutiny. There's more requirements. Right or wrong, I think that, basically, that the government should be knowing what's going on there, but they're requiring more documentation, whereas before they weren't. I think the requirement was there. It was more lenient.
Trinidad Galdean, let's give him a big.
Thank you.
Thank you, sir. Thank you, sir.